We'll continue our coverage of the NPP's primaries in its constituencies where there are sitting MPs for you all through the day, so keep your dials here. But for now, let's take a little pause and look at other important matters that need to be discussed. As you may have followed in the course of the week, the TUC, Organized Labor, is threatening a Luta demonstration over tax on electricity. They gave the government seven-day ultimatum to back off, completely remove it, or suffer in their hands. How will that work? The MacPam coup plotters, 3 escaped death by hanging. 6 are to be hanged, to die. We'll tell you deep into the judgment how the 6 that have been convicted planned, actively planned, purchased weapons, manufactured weapons, spoke about abducting the president, the vice president, and other people, spoke about throwing bombs and seeking, knowing that people will die, but telling themselves that it's the price to pay. How they got army officials to recruit junior officers at 50,000 cedis per recruit, and how others, the 3 who escaped, appear to have been wrongly added to the list. On reasonable suspicion, though, because they got involved on a WhatsApp platform. We'll tell you how exactly they escaped. The case of the OSP discontinuing all cases against Cecilia Dapaah and referring the case to the IOCO to continue on the matter of money laundering. Is the OSP simply running away from this case? The Electoral Commission is pushing for elections in November. A good thing to do? It appears the NDC is back to IPAC. I'm Samson, Lardy, Anyenini. We'll be right back to deal with the vexed matters. Welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here is Samson's take. Compensate 247 victims. Punish the criminal wrong against a shyman. It has taken too long, in my estimation, for such a major and urgent matter. In any serious country, this official inquiry would have been completed and in the matter of days or weeks, and the errant soldiers sanctioned and the poor victims of the egregious human rights abuses adequately compensated. I insist that what the military did on March 7, 2023 was state-sponsored terrorism against innocent members of the Tulaku and Taifa communities in Ashaiman. The report of Parliament's Committee of Defense and Interior, dated November 2023, and now intercepted by Joy News, is a good first official report of admission of wrong, criminal wrong, and unconstitutional harm to people and property by the military, paid to protect these people. Hopefully, the perpetrators will face lawful action forthwith to send the right signals. The Commander-in-Chief has an obligation to the people and the Constitution he swore to uphold to make a statement not in words, a statement that accords with his oath and obligation by swiftly letting heads roll. I'm talking about the supervisors of the dastardly act. Hopefully, the victims have been properly accounted for and the compensation will be swift and adequate. In March, we were giving 184 as the number of victims. This obviously was only the number detained or abducted and later released by the army. Oliver Barker-Vormawor, who mobilized lawyers to record what happened to victims, found far more than lawyer Emmanuel Kumade's 247 adopted by the committee. Army leaders and those in charge of security of the state told the committee the army moved into Ashaiman, quote, after all intelligence had been gathered, end quote, on the killing of the young trooper. An intelligence operation. It was. Really? An intelligence operation that saw the soldiers, as captured in the report, jumping and scaling walls into homes, breaking doors and waking innocent people from sleep to beat them, drag them out into the rain and mud, line them up and flog and inflict serious wounds on them. The police, they got intelligence. They picked up 6 suspects who, shockingly, were not part of the hundreds picked up by the military and tortured. They suffered torture, cruelty, inhuman treatment, and punishment, or conditions that detract from their worth, with impunity and in violation of the clear provisions of Article 15 of the 1992 Constitution of Ghana. How difficult is it for a state professional security body, fully armed to the teeth, how difficult is it for them to comply with this provision on arresting, restricting, or detaining suspects of crime? They are to be treated as innocent until they have confessed or have been found guilty, not by you, but by a court of competent jurisdiction. That's what happens in a democracy. You don't pick them up, whip them up, pick them up, old men, whip them, flog them, and inflict injuries on them. Are you a security organization? Shockingly, only a few organizations, including Occupy Ghana and CDD, issued statements condemning the wrong and demanding swift action. CDD's Professor Emerita Techua Menu is not tired of defending human rights and freedoms. If you think you are getting tired and so you will not talk, things will get bad. She has been at this since the 1980s. It was great to see her honored with the Franco-German Prize for Human Rights and the Rule of Law 2023. In observance of International Human Rights Day 2023, which coincided with the 75th anniversary of the United Nations General Assembly's adoption of the Universal Declaration of Human Rights, which we have put in our Constitution. 11 individuals from around the globe were honored for their exemplary efforts in advancing human rights. The Franco-German Prize for Human Rights and the Rule of Law recognizes the dedication of civil society to the preservation of inalienable human rights and the protection of human dignity for all. Our Constitution says the dignity of all persons shall be inviolable. On January 22nd, 2024, in the residence of the French ambassador to Ghana, she was presented with the award during a beautiful event that was held in her honor. Professor Techua Menu is Emerita Professor of African Studies at the University of Ghana. Previously, She was Professor of African Studies at the University of Ghana, where she also served as Director of the Institute of African Studies between 2002 and 2009. She has also been Director at the Social Development Policy Division of the United Nations Economic Commission for Africa in Ethiopia. She received her PhD in anthropology from Indiana University, Bloomington, and holds undergraduate and graduate degrees in law from the University of Ghana, Legon, and the University of Dar es Salaam, Tanzania, and has done research in areas for African development, women's rights, empowerment. You know why I'm reading this to you? See where she is, and yet she doesn't get tired of defending this constitution of ours and the rights of the ordinary Ghanaian. Please don't give up. Continue. It doesn't matter how long you have been doing it. And that is my take. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile we put Ghana first. So, my guest to help us with the first discussion, Dr. Dapaah, he's Secretary General of the Trades Union Congress. Samuel Dubik Mahama is Managing Director of the Electricity Company of Ghana. Ofosu Amwa is Executive Secretary of the National Labour Commission. We have others who will join us for the other segments of the discussion. But as you are aware, or you may be aware, the Finance Minister issued a statement, and I share it with you. Implementation of value-added tax, VAT, on the supply of electricity above the lifeline for residential purpose. As part of the implementation of the government's medium-term revenue strategy and the IMF-supported post-COVID-19 program for economic growth, PCPEG, the implementation of VAT for residential customers of electricity above the maximum consumption level specified for block charges for lifeline units in line with Section 35 and 37 and the Fair Schedule 9 of the Value Added Tax VAT Act 2013 has been scheduled for implementation effective 1st January 2024. For the avoidance of doubt, VAT is still exempt for, quote, a supply to a dwelling of electricity up to a minimum consumption level specified for block charges for lifeline units, end quote, in line with Section 35 and 37 and the First Schedule 9 of the Act. The Electricity Company of Ghana, ECG, and the Northern Electricity Distribution Company, NEDCO, are hereby requested to liaise with the Ghana Revenue Authority, GRA, to ensure that the implementation of VAT for residential customers of electricity above the maximum consumption level specified for block charges for lifeline unit takes effect on the 1st of January 2024, in line with the sections and schedule already mentioned above. By a copy of this letter, GRA is requested to ensure that it liaises with ECG and NEDCO for the transfer of the revenues collected from the implementation of VAT on the subject matter as part of its domestic VAT collection. We are counting on your usual cooperation in this regard. Ken Oforiatta, Minister, and distributed to those who must have copies. Dr. Dapaah, you have been very straightforward in saying that this will not work. You said, you guys say, we won't pay. And you have given government 7 days ultimatum to completely scrap this. We are broke. We're in IMF. We need help. We must begin to help ourselves. Is that not what is being done? Did I lose Dr. Dapaah? Okay, let me try if Ofosu-Amoah has a good connection. Thank you for joining us also. What do you say? What do you say to the question I just asked, Ofosu-Amoah? Okay, so we understand we have a little difficulty with our lines there, but we'll try and get those two gentlemen back on the line. So, Engineer Benata, thank you very much for making time to join us on this. Are you there?
Thank you. Yes, I'm here. Thank you very much.
Great.
And let me greet all your viewers and listeners as well.
Why should we not be paying this? Why should we not begin the process of the economic recovery from home?
Something. You may agree with me and possibly agree with government that our revenue sits in our home. And therefore, if there is a need for government to mobilize any revenue, especially from fair wages point of view, to be able to pay the necessary compensation to public sector workers, obviously, we need to mobilize the revenue. So, if at some point in time, organized labor does not agree with government with one tax or the other, there is a need to really sit down and look at the issue. The demonstrations, the ultimatums, and the rest have their place elsewhere. But in this issue of nation building, I think we should commit ourselves to dialoguing. And from our point of view, government indeed needs revenue. Do not forget that for the past week, a number of unions have agitated. A couple of them had been on strike, asking for payment of their tier 2 and the rest. So obviously, if we are the same people to be able to support government to raise revenue in order to also take care of us, why not? Why not? But
all right. So just kindly hold on for me. Let me go back to the Secretary General of the TUC, Dr. Dapaah. Dr. Dapaah, so I'm saying that the 15% VAT on electricity, you say that's a killer tax, we won't pay, 7 days ultimatum, government must just withdraw it. Why?
I'm sure you know why, and all your listeners know why. As the situation we find ourselves in this country, I don't think what we need is more taxes. We need something else to build how we live the people of Ghana. What we need, what we want our leaders to do, is not taxes and taxes more all the time, especially poor people. We need something else, not taxes. And we are hoping that they will listen to us, so there will be peace in this country, because we will never accept that tax again. And we have made it very, very clear to government.
You will never accept, but in the communication to the right authorities that are supposed to begin the collection of the tax, which is supposed to be effective the 1st of January, the finance minister's communication was clear. This is part of the process to economic recovery. We're already here. We need to come out of the pit. So we must help ourselves. Is that not what he's doing?
Yeah, there are many other options. And that is why stakeholders must come together to discuss where we are, we agree where we are going. Where the situation we find ourselves in, it is not the finance ministry which is going to take us out. It is all Ghanaians, especially stakeholders in industry, in labor, and even the political parties. All of us must come together, farmers, and all. So we discuss and agree where we are, we discuss and agree where we are going. This idea that wisdom is in the head of only people in government, we should learn to change that kind of perception. I can assure you that if we come together all of us together in one room, we will find a solution that will not involve taxing poor people, going into their houses to tax whatever is happening over there. It is not right. I mean, it doesn't matter whether you have an IMF program or not. The situation we found ourselves in the last 2-3 years, it is irresponsible on the part of government to tax Ghanaians again. It is not right. We can change it. I challenge them to bring all the stakeholders together. And my brother, I can assure you this country will get out of this mess.
I realize that the focus has been on the VAT on electricity.
Yes.
And that is in paragraph 9 of the schedule to the law. But in paragraph 8 of the schedule to the law is the same tax for water. It says supply of water, excluding water commonly supplied in bottles or other packaging suitable for supply to consumers. Then 9 says supply to a dwelling of electricity up to a maximum consumption level specified for block charges for lifeline units.
Yes, absolutely.
In much of what we have heard you talk about, your focus has been on electricity. Because, of course, the finance minister issued a letter asking that the collection should begin. But the law, in the law, it is not only electricity, it affects water as well.
Yeah, but this law was passed in 2013. This is 10 years ago. And no government has ever dared to implement them. I mean, these are not good laws. The laws themselves must change. You know, we have found ourselves, the fact that there is a law that is needs to be implemented. We are in a different situation. And every responsible government will, make sure before you implement a law, the society can fix it. We are in a situation where we connect. And so what we need to do is change the law. Make sure Ghanaians are a bit more sympathetic. This is not a big law. It's easy and honorable. And so we expect government to use this project to change it instead of implementing it.
The finance minister and government generally have been preaching burden sharing. Burden sharing.
Yes.
Shouldn't that be our attitude as citizens? Because you just said that it takes all of us to get out of the problem that we have been, sunk into.
Let me tell you, if we get together, we can actually do our burden. If we say that it's just unidirectional now, because the burden cannot be reduced, cannot be avoided in itself. I want to assure if the Ghanaians sit together, they will tell the Minister of Finance how to reduce the burden, not how to tell it. Even if we manage to reduce the burden and the regulations there, the Ghanaians will understand. But you don't go increase the burden for the people and preach that you should share.
You gave a 7-day ultimatum.
Yes.
What is today, and what responses are you getting from government, and what are your plans?
We've got some responses. I'm not sure if I have to discuss that. Even when I was driving this morning, I received some phone calls. I'm not sure if I should discuss this on radio. But we gave up to 31st of this month. Today is 27th. We don't have a lot of time. And I hope that this government will act very quickly, to ensure there is peace in this country. Otherwise, I can assure you, my brother, after 31st, you will hear from organized labor. We are committed, we are determined that this tax will never be implemented. And we will do whatever it takes for government to take the stand on it.
Is it not instructive that even though there have been instructions for the collections to begin or the charge to begin, and yet it has not started.
Our sense are that they have not started. I mean, they have to reconfigure their system to start. But I don't think that they need to reconfigure anything because this tax will never start. It will never be implemented in this country called Ghana. We will not allow it.
The law should be repealed. The law should be revoked.
Yes, because it's bad law.
All right. Thank you very much. Dr. Dapaah is the Secretary General of the TUC. And as I tried to introduce to you earlier, and we didn't have a good connection, or we just didn't have him on the line at the time, let's attempt to speak to Ofosu Amwa, who is Executive Secretary of the National Labour Commission. Okay, so now let me finish up with Engineer Ben Arthur of the Fair Wages and Salaries Commission. But you must be concerned about organized labor's, posture to this. And now in our various educational institutions and elsewhere, there are threats of, strike actions because people have difficulties, and yet the government is seeking to slap more taxes on them. And you are not giving them extra pay.
Hello?
Yes, Ben.
Samson is not exactly the point that we have explained. Do not forget that in 2023, government increased public sector pay by 30%.
That's correct.
And for me, that is the biggest jump in the history of this country.
But it's important to know what the value of that money is today.
Yeah, so do not also forget that this year, and for those who received their pay in January can confirm to you, that government again increased the pay of public sector workers by 23%. That is for the first half of the year. And then in the second half of the year, an additional 2% to make it 25%. So it is not correct that government has done nothing about the pay of workers in this country.
So it's not a good excuse to say that the ordinary person is being overburdened with taxes without commensurate, as it were, remuneration.
I have not done the mathematics to support exactly what you say, but you must side with me that government needs to mobilize revenue. Where are we going to get it from? Obviously, it has to come from us. But of course, if there's a section of the public that is aggrieved, especially public sector workers, and the workers of this country are aggrieved about the policy or a law that has been passed by Parliament, definitely for implementation, there's a need to dialogue. And for me, demonstrations and ultimatums might serve their purpose, but that is not the best of approach. Dialogue is the way forward. It is also important that even as we demand what we think is due us, we do not cause mayhem. We do not destabilize the peace that we have as a country. And for me, that is very paramount. We've done this over and over and over again for many years of dialoguing and making sure that we have always had a solution that fits the individual interest. So government definitely will be dialoguing, and especially for those of us who are pay administrators, anything that relates to pay, as we have always demonstrated, we are always willing to dialogue. You should not forget something. Yourself, you are a lawyer, and you know in the Constitution, we are mandated as citizens of this country to also contribute our quota. So the question is, in this challenging time, where is our quota? What must we do? And how must we do it? So we all have the joint responsibility to make this nation work. So if government is asking, I do not think that it is a joy of any government in this country to be imposing taxes every day and night. I do not think so. But we have a challenge that must be resolved. In times past, when government could not raise revenue, and we had very difficult times, what government resorted to was to lay off workers. You and I have been long in this country to start in the 80s, when there were a lot of retrenchment, layoff, and the rest. Is that what we want to witness in this country? Obviously, no worker, especially in the public sector, is willing to welcome such news. That is an alternative for government in order to cut down its budget. That's also an alternative, but is it an alternative that speaks to the well-being of our colleagues who work in the public sector? So there is a need to strike a delicate balance.
Right. But the Constitution, yes, the Constitution you refer to, that imposes a duty and obligation on all of us in Article 41 to help the country cooperate for the enforcement of all that is necessary to make the country a good place. Also says that people must work conscientiously in their lawfully chosen occupation, and they are saying that they are working conscientiously and they are not getting what is their due, and they are seeing the leadership engage in waste. And that same provision speaks about people having to protect and preserve public property and expose and combat misuse and waste of public funds and property. So it's the two must go hand in hand.
I agree with you. You know, when it comes to pay administration, I'm well able to speak to that issue. But you raise a concern whether people are remunerated adequately or not. You must place it in its proper context of capacity of a nation to be able to do what we are asking for as a nation. I must be proud that in Ghana, we are one of the few countries that sees employment as a fundamental human right. And being a lawyer, you know that the right to employment and the protection of one's employment are part of the fundamental human right. Because of these entrenched positions of our law, government has a predisposition towards protection of employment. And do not forget that when we had COVID, and it necessitated that some numbers of our workers needed to be trained, government opted for the option of protecting the employment and keeping their pay intact.
All right.
And for those who stayed at home, that because of the exigencies of the time we could not engage them, they were all paid. So it is not always the case that government wants to take something from workers. It is not always the case that government wants to impose taxes that are unpopular. Mind you, 2024 is an election year. And if there were not any demanding necessities that are very overburdened on all of us, no government in this status will want to bring a new tax to become unpopular.
All right, thank you very much, Benata. Benata of the CEO of the Fair Wages and Salaries Commission, also making an appeal to those who are intending to get into various forms of, mass actions over the economic hardships, while taxes are also being imposed on electricity and also on water, but that one has not yet kicked in. Ofusama, Executive Secretary of the National Labour Commission, it's going to be a very busy year for you. How are you seeing things? This is the very start of the year, the first month.
Hello?
Yes.
Hello?
Yes, I can hear you.
Yes, please, could you repeat your question?
We're starting the year on such a note of potential tensions in the labor front. How are you assessing the situation, and what are your plans? What should be done so that they don't happen in the first place?
Oh, thank you very much for calling and giving the audience of this platform. Actually, if you look at the way things have worked in the past, when it's getting to the election year, I mean, there is this mass citizen and protest. Everybody will want to get what he wants or what he deserves. So as a commission, we are prepared for it. At least that is what we are created to do, to solve problems and to make sure that the industrial and the labor front is quiet. Our 7-member commission are up to the task. We are very experienced people and committed to doing the work. Of course, we have the assistance of our mediators and arbitrators and all the efforts we can tap on. We've also tried to cultivate the relationship with the union leaders, of course, the employers, and the government to make sure that we are successful in keeping the industry and the labor force quiet. Of course, like you just heard from, I think the CEO of Ferry, and of the fact of notoriety, things are not easy for employers, neither is it easy for government when it comes to payment. And in the same way, for the workers and employees like you and I, it's not easy for us because we all have responsibilities and duties. I mean, where we all need money to perform. So it's not easy for any of us. So it's a matter of sacrifice, giving concessions, negotiation, and coming out with the best. So that's the problem now.
All right, we wish you the best as you start the year on such a note in your offices. Now, let me come into the studio and speak to Samuel Dubik Mahama, who is the head of the Electricity Company of Ghana, to whom the letters were directed to, together with the GRA, to make sure that the 15% VAT on, Lifeline is collected. He has also been speaking and actually feels that the tax will be very difficult to implement unless certain things are done. So, from where you sit, the government's plan is that help the state to get more money because we need to get out of IMF. We need to take care of ourselves. And the instructions have been given to you and the GRA to collect the money. So how come we're hearing you say it's going to be difficult to collect this money?
Good morning. This brings us back to the fact that when a letter is sent to you and the letter doesn't belong to you, and you read the letter, you would pick what you want to pick out of it and leave what you want to leave out of it. If you read the letter, there's a major conjunction there that says liaise. As an implementation organization, what we have to do is look at liaise, because liaise will come with a lot of implementation structures. This is something that has not been done before. So when the letter came, we read it for what it meant. We knew the stakeholders, the conversations that are supposed to be had. Now, there are a few challenges that would come that we have to share with everybody. The first one is, who is a Lifeline customer? It's someone who uses under 30 kilowatts hours. Now, if that's the case, that means you are charging on consumption. But if you're charging on consumption, consumption is after the fact, after you've consumed. You understand? So now brings us to a problem of prepaid meters.
Correct.
A prepaid meter is a deposit. He hasn't consumed yet. So am I to charge the VAT before? And if it's before, that means I'm charging on the price that you are purchasing. Mm-hmm. If I charge on the price that you are purchasing, I will not know your true consumption.
But that's what I'm buying,
yeah.
And I will use that anyway.
Yeah, but that is not your true consumption. Consumption is after the fact. So, and you know, as they kept on saying, and as I'll use against you, you as a lawyer, a tax must be equitable. It must be fair. We have operational challenges. So this is something that has to be looked at clearly and spelt out. Because no matter what you do, there will be times where tariff will change. When the tariff is changed, there will be chaos.
Explain to me again. If I enter the restaurant and I'm buying food, I'm paying VAT on that food I'm buying.
Yeah.
That I'm going to consume that food. It's not the business of the tax man.
But
so if I'm purchasing power credit, you just take the tax from it. Why should you say you don't know how much I'm going to consume when I've bought 20,000 worth?
Did you eat all that food? The food you bought, did you eat it all? I'm asking you.
That shouldn't matter.
It should matter because that's why there's a meter. That's the use of a meter. The meter is to calculate your consumption. Your consumption is your consumption. And you want your customers to have confidence in the bills that you are churning out.
For the prepaid user,
yeah.
If I purchase 20 CDs credit,
yes.
Are you suggesting to me I could use half of that and come to you and demand the other half?
No, because if you're buying 20%, that means if you're buying 200 CDs, am I to charge the VAT on the 200 CDs and add it to the 200 CDs for you to pay that deposit? Then that means I'm charging on price. That means I'm charging on price. I'm not charging on consumption. So if the whole country, let's say in uniformity, the whole country was on postpaid metered, yes, you could try something like that because everybody consumes. With that one, you consume, we read the meter, then. But that's not the case. So if you do this, a certain group of people are going to be burdened, others are not. And you have to even out the burden. You understand?
And you have more prepaid than postpaid. You are actually
now
going
we are
towards
50-50.
prepaid.
Yeah,
50-50.
And now we are vigorously going towards what do you call it? Prepaid. So it's a conversation that needs to be had with all stakeholders. But again, everybody points to that. You see how the TUC boss said it's a bad law. It was passed in 2013. Nobody has implemented it. The mere fact that a law has been passed and somebody has implemented doesn't mean that the law is not valid. Now, we need to take steps to know why that law was passed in 2013 and what the framers of that section, what their thinking was. What interpretation-wise, what mischief were they trying to
What's
do?
your understanding?
For me, it's too vague.
What makes it vague?
Read it yourself.
What makes it vague?
Because it
says that a supply to a dwelling of electricity up to a maximum consumption level specified for block charges for lifeline units. I thought that this is your language and you understood this.
It is too vague. Then that means if you are my best friend, all I'll tell you is what? This is how much 30 kilowatt hours cost. Every time, make sure that's exactly the amount of money you are buying in prepaid. Then that means what? You have circumvented the law. Then what has the law achieved? You circumvented the law. So that's what I'm saying. The law is too vague. What is the law trying to achieve? Because if to bypass 21%, everybody will be purchasing under I'll purchase right now, 30 minutes later I'll send my son to purchase again. Then we will just make mockery of the law that we've put in place.
No, but you know, practically that doesn't work. There are many people who need electricity in a certain quantum and they can't afford to be purchasing 30 kilowatts, 30 kilowatts.
Those who need in those quantum are the commercial ones. They are already paying the VAT. They are already paying VAT because it's value addition to the business they are doing. So commercial owners, SLT, big bulk customers, they all pay VAT. But the conversation now is about residential, where you live with your family. It's your livelihood. You go to work, you come home. That's what I'm saying. We need to go back to the framers of this law to find out exactly what the thinking was. What mischief were they trying to cure? Why they said, because if we don't solve this, as you pointed out, water is right above electricity in that section. What's going to happen next? So we are saying there should be a broad stakeholder conversation where, one, if it's going to be implemented, how are we going to do it to make it across board? If it's going to be fixed, it's not going to be fixed. But we see the letter that came as a letter that's supposed to provoke conversation and also allow for us to come to the table to see what needs to be done and then the right things put in place. So for us, as a company, it's working together with all our stakeholders, all our, as we always say, all our cherished customers to make sure that we can meet them at their point of need and then make sure when you are charging a tax, it is equitable in nature and everybody is comfortable.
But the laws that are referred to in the Act, Section 35, says exempt supply. The supply of goods and services specified in the first schedule, and that's where we have gone to read 9, which talks about electricity, and 8, which talks about water. The supply of goods and services specified in the first schedule is an exempt supply and not subject to the tax. Section 35(2). A supply of goods or services is not an exempt supply if that supply is subject to tax at the rate of 0% under Section 36.
Counsel, you see how you are suffering.
I don't get it.
When I say the law is vague, the law is vague.
Okay,
we need
I was sharing the schedule with you, but now we are reading the law itself. This is 2013.
It's too vague. It's
and
too
it doesn't
broad.
make sense.
It's 2013. So look out, the country is now in 2024. We need a broad stakeholder engagement. That is if we want to implement. And that's why I like what the finance minister wrote in his letter. Liaise. So go and sit down. Go and Jojo. Come back to me. You understand?
You were giving effective 1st January for it to kick in.
That means the liaison is still going on. The Jojoing is still going on. So if you... And I love the way everybody is jumping on. TUC is bringing their viewpoint. Fair Wages just spoke. Let's all sit down and let's all come to an amicable conclusion. And let's see what we want to do or what we need to achieve. That's what we are saying. But it's a difficulty, and it will be a nightmare. And you don't want to overburden customers in putting something in place where they will never trust their bills. If you, as is right now, we always have people challenging their bills, and we are trying to solve the problem. So we need to find a way to work together to make sure that the gap is closed quickly and we have a working formula.
So you are working to ensure that this is implementable? Because those are your instructions.
We'll go back to the finance ministry. As I said, I already had conversations with the energy minister. It's a policy directive. So when a policy, the corporate governance wise, if I'm not able to implement, I have to come back and state the reasons why I wasn't able to. But if you remember 2013, we were in a similar situation as a country. So those who passed the law, what was the thinking? Now we are where we are now. Is it something that's still valid? So sometimes when we are making laws, we have to be careful. That's the whole thing. Because if you pass a law that you can't implement, then it's going to stay on the books.
How soon do you expect that you finish your work on this?
We are going to have some conversations in the next 2 to 3 weeks. But however it goes, definitely will. But clearly, if we are going to implement, there would be an announcement.
All right.
So rest easy. It's not being charged now. Let's keep calm. I still like the conversations going on. Conversations are going to help all of us to get to a consensus. And then we can find a good way forward.
Okay. Thank you very much. But from the TUC, I can see that they want a firm commitment from government that this law will be abolished, or simply an announcement that it's been withdrawn. The attempt to implement it has been withdrawn.
You know, when you withdraw it, if the finance minister withdraws this letter, what stops another finance minister from implementing it? For us to come back to where we are.
This law has been in since 2013 and it's not been implemented.
That's why I said, if you have a law and you don't like it, or you have a problem, now the conversation has started. Let's all get to a consensus.
There are laws that were passed in the 2000s that have not been implemented, including ROPA.
If we are going to talk about laws that we've not implemented, there will be a whole lot lecture.
All right,
today.
okay.
But
let
me take this opportunity to also do some advertisement for ECG.
Okay.
As for the 1st February exercise that we are starting on Operation Zero Consumption, please, 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 especially those on the postpaid meters, you are not paying your bills. And you not paying your bills is hurting us as a company, it's hurting the entire food chain. When the exercise starts, as I've already said, Samson, these days I don't have friends because I sell electricity. Please do your best to settle your bills. Get onto the app, pay your bills, especially the postpaid customers. It's so easy now. All of you who feel your bills, you've been overbilled, there's a portion on the app that allows you to send in your meter reading for us to compute it and bring you the actual, and then we pass an adjustment. We do admit, and I must say on record, we do admit that because of some past readings, some of you have a wrong bill. So please do your best to either send us those readings or allow us to read the meter. I think some people just don't want us to enter their compounds for some reason. But
or just migrate to prepaid and...
But this year we are reading both prepaid and postpaid meters. Nobody should think that a prepaid meter cannot be read.
All right.
It's a meter that has to be read.
All right.
So those meters are going to be visited
once in a while. Once in a while,
exactly.
We get that happening. Okay.
Yeah. So
right.
This year, that's what we have on board.
Thank you very much.
Thank you
Samuel Dubik Mahama is the managing director of the ECG, and we take a quick break. We return to the matter of the coup plotters, quote unquote, and the judgment of the court in that regard. We'll be right back.
I serve a living God, and that's how come I have been so confident. Yesterday you saw that I wore white to that place. None of the accused persons wore white.
Did you know anything that the rest of us did not know?
I knew I was going to be acquitted and discharged by the grace of God. One, because I knew they had no evidence against me. Two, because I knew I was being persecuted. Three, because I know that their evidence was fabricated and therefore without context, and that when brought to serious scrutiny, they will fail. And fourth, because I believed in the judges, by their conduct and everything. I may have challenges, but I knew that they, by their utterances and other things, they were going to... Yes.
Staying on the platform and talking about Arab Spring.
Does he understand Arab Spring? If he doesn't, he should keep quiet. If he doesn't understand Arab Spring, he should keep quiet.
But he's a lawyer.
He's a lawyer, but being a lawyer doesn't mean that you know everything. You can be a lawyer and be an ignoramus in an area. I teach conflict. When you look at Arab Spring, it is like any other spontaneous demonstration by citizens to express their dissatisfaction.
Which in the reality and the examples...
If it leads to the fact that a government decides that, do you know that we can... The Kumi Preku could have led to Rawlings saying that, okay, I've resigned. Could it have been called Arab Spring? The Kumi Preku in Ghana...
I'm not sure.
Could have led to Rawlings saying, okay, I've resigned. Once the VAT has been defeated and other things have resigned. When you go to the literature, go and Google it anywhere. Be careful you don't go to Wikipedia. Go to other sources and you to tell you the real meaning of it.
And you say that's what they confronted you with, a Wikipedia definition of it.
A Wikipedia definition, their myopic understanding of that term. And that is what they confront. And that's what they have held on to till today. And that's what Attorney General is still holding on to. He should go and learn. He should go and learn. Because he's not dealing with just people. He's dealing with people who have also climbed the ladder somewhere. Who appointed them? Where is their loyalty? Don't answer. Now, the Inspector General of Police shall be head of the police service, but shall be subject to the provision of the article and to the control and direction of the police council. Who is the police council? Headed by the vice president, who is also a party member and a member of the government. What kind of advice do you expect from him? Now, the third one, subject to the provision of the Constitution, the power to appoint persons to hold or to act in an office in the police service shall vest in the president. Are you getting the point? Now, if he is the president, what else do you expect? Acting in accordance with the advice of the police council. Who is the police council? You know. Sorry. Now, I just want to go to the police council for you to see the difference. What I'm really talking about. Yeah. All right. Now, this is the composition of the police council in that. The vice president. He's a party man. It doesn't matter whether it's MPP or NDC. This is what we have given us, and this is what we work with. Now, a minister responsible for internal affairs, who is he? He's a party man. Then you have the Inspector General of Police appointed by the president. The president can dismiss him at any point in time, and therefore his loyalty is partial. It doesn't matter whether he was appointed by MPP or NDC. His loyalty is divided. Because he can be appointed today and dismissed tomorrow. And the worst scenario is when he is appointed to be acting capacity. It means I'm watching you. That is what it means. Now, the Attorney General is a party man.
And you've been listening to ACP Dr. Benjamin Kwesi Agodjo. He, together with two others, escaped the verdict of hanging by death. He, together with Colonel Samuel Kojo Gameli, a senior military officer, and then Corporal Seidu Abubakar of the Air Force Base. Now, how did they escape? According to the judgment, after the prosecution had called 13 witnesses, and according to the judgment, a total of 23 persons testified in this case, the court found that A5, A7, and A10. A5 is Colonel Samuel Kojo Gameli, that's a senior military officer. A7 is Corporal Seidu Abubakar of the Air Force Base. And then A10 is ACP Dr. Benjamin Kwesi Agodjo. The A5 essentially was, there was a WhatsApp communication that was discovered between him and a nurse of the Citadel Hospital. The Citadel Hospital is the hospital owned and operated by Dr. Mark Palm. That is A1, that's the first accused person, Dr. Mark Palm. And as you may come to realize in the judgment, that hospital became a place of meeting, a place of hoarding, manufacturing locally made guns, and hoarding other pistols and weapons. So there was a WhatsApp communication that was discovered between him and a nurse of the Citadel Hospital upon the arrest of Mark Palm and his friends. There was the allegation that he confessed to knowing about the activities of the TAG group. So Dr. Mark Palm formed the TAG group, that's the Take Action Group. So the people who testified, who are soldiers and people of the NIB, formerly BNI, say that he confessed to knowing the activities that the group was involved in, that is, plotting a coup. Unfortunately, the judgment found that they could not back up this claim with evidence, because there are people that were said to have confessed. The evidence was there and it was shown. But you say Samuel Gameli also confessed and you can't show us the evidence. He was only mentioned by his subordinate to Mark Palm. He was said to be one to provide communication support for the coup. So he was charged with abetment. Remember, two were charged with abetment, he and ACP Benjamin Agodjo. And he was set free because prosecution could not back their case with evidence. When it comes to Corporal Seidu Abubakar of the Air Force Base, the main thing is that for him, he was seen once, only once, in one of the meetings, the many meetings that were held. But he proved that he had accompanied a colleague of his, like a roommate of his, one Ali Solomon. That is A8, accused person number 8. That they went to the market to buy fish. And on their way, the friend Ali Solomon got a call asking him to come. And you see in the judgment that Next Door Beach Resort is a prominent place in the judgment. It's a 96-page judgment. I took my time to read all of it. It definitely will become seminal on this kind of cases in this country. Now, he said somebody called, a colleague called that somebody, wanted to meet him at the resort, next door beach resort. So they were together, so they went there. But when they went there, he sat far away from his friend and the other accused person who were having their discussions. So he didn't participate in the discussion, so he doesn't see why he was brought in this matter. And he was never on any of the videos of the group plotting activities. He was charged with conspiracy and the substantive crime of treason. He also got acquitted because there was no case could be proved against him. And then A10, that is ACP Dr. Benjamin Kwesi Agojo, a senior police officer. He was outside of the country and was invited to join the platform due to his public advocacy. And we played you a video. You remember, this is what actually brought him to the limelight. He was leading the police and at various fora by governance entities. He was giving the speeches and driving that we needed to change the constitution, among other things. There had been platforms where I had the privilege of, mounting and speaking with him, with the CDD, Codeo, review of an election. He was there representing the police to speak for them. And I was also there to give a paper, present a paper. So these things made him popular. And the thing was that this is what led to, Dr. McPalm inviting him to join their group. He said he found out about the group and he was told that the group was an NGO that was involved in medical outreach, among other things. So he made a donation of 2,000 cedis to support a medical outreach of the group. The court found that there was no proof that he was ever on the TAG executive platform. So the TAG, the Take Action Group, they appear to have had several platforms. They had a general platform, they had some other platforms, but there was the executive platform. And it appears that it was on the executive platform, it's a WhatsApp group. So on the executive platform, that those who were discussing the things that were about plotting a coup took their, decisions. And he was not on that platform. So the cross-examination came on. Martin Pebu is sitting here. They asked the people who came to testify for the state, and they couldn't find. They said, I can't recall. I don't remember. And in criminal prosecution, once there is a doubt, it inures to the favor of the person who is accused. And the court said the prosecution failed to prove mens rea, intention, that he knew, he had knowledge, and he intended to assist or he encouraged McPalm to plot to overthrow the government. So he got off on that as well. Thank you very much for indulging me. Let me come to the studio and begin to speak to my guests who have joined us, including Martin Pebu. But before that, I think it's important. When the state went to court, among the things they said about the group, it included this, that the group members held meetings. Several issues were discussed, some of which included the recruitment of more soldiers, the acquisition of weapons and bulletproof gear, development of sketch maps, and this was tendered in evidence because it was actually developed, sketch maps of key installations and facilities of the state to be attacked during the takeover, They also discussed the procurement of electronic jamming devices and vehicles. When you read the judgment, those who were contacted, the military person who was contacted in Ghana said he couldn't help. And he is with a communication sort of group in the military. He said he couldn't help, but they needed to get it from abroad. And according to the judgment, MacPam assured him that they were going to get it either from the US or from the UK. So they also discussed procurement of electronic jamming devices and vehicles that would enable them to take over the National Communications Authority and jam all radio stations except for the Ghana Broadcasting Corporation, GBC, where they intended to broadcast their successful overthrow of the government from. Among others, they spoke about how to capture the president. They also planned to force the president to announce his overthrow once he was captured. There were discussions on whether or not to kill the president in the process of overthrowing the government. To facilitate their communication in the grand scheme of overthrowing the government, the third accused supplied some members of the group, including the 6th, 7th, 8th, and 9th accused persons, with mobile phones. The fourth accused being a staff of the signal unit, that's what I meant to say, signal unit of the armed forces, and with knowledge of various communication gadgets, was recruited by the fifth accused to support and aid the first accused to procure communication and jamming equipment for the plot to overthrow the government. They contracted the second accused person from Alavanyo to manufacture explosives and pistols. He was brought to Accra and he began the manufacturing of the pistols and explosives, where they had converted the X-ray laboratory of the Citadel Hospital belonging to MacPam, the first accused who died in the course of the case, into a manufacturing shop. So this will be my attempt to try and tell you what the prosecution was telling the court. But before, I want to read a portion of the judgment here. There was an exhibit G13.
Let me interrupt you briefly. The facts you just narrated, the plot of the coup. But then Agojo was not on the platform.
Correct.
He was.
Correct.
So
the platform was set up in 2017.
Yes. So he has no knowledge at all.
So wait, let's get there. Then there was an exhibit 13, a very important exhibit. It was the transcription of the meeting held on the 28th of July 2019. You know, I had begun by saying ACP Benjamin Agojo was outside of the country.
Oh no, I understand.
So, okay, right.
Yes.
So
the testified for us, so you can't be doing it. Yes, Sam. Oh, please.
Wait. Let's get there. Let's get there. Yeah. Right. Okay. I did what my conscience and I felt a godly duty I needed to do for a man who had contacted me and was asking me and seeking my advice to help so that we go to the Supreme Court to get the court to make interpretations that will help to sanitize the system, security system. So I went to court to testify in that regard on his behalf, because he has said that, look, everything I've been doing is public. I have nothing to hide, and I don't intend to support any coup. I intend to support a constitutional reform that changes things. And I had the opportunity of, you know, presenting papers at some of these places, IDEC, CDD, Codeo, election review meetings in Aqua Safari with him. And so I just felt it was a godly duty on my part to go and testify for him against all the odds.
Thank you.
Now, let me finish with this. So they transcribed the conversations that happened in a meeting that was held on the 28th of July 2019. And here is what transpired. In these discussions, with 8th present, and which he contributed to, for instance, discussions were had with Dr. MacPam on how much ammunition will be needed and the casualties. In fact, at page 6 of 28 of Exhibit G13, for instance, A3 was asking whether the trigger for detonating the bombs is like remote control, to which Dr. McPalm responded inter alia that, quote, "We don't want to kill too much. If killing comes, it is just the way it should be. But we should be able to do this in a way that casualties will be on the minimum side." So those things he's talking about are very, very, very dangerous things. They are very, very dangerous. He said they can scatter this whole place. In the same meeting, discussions were had per Exhibit G13 about how to deal with the president, vice president, chief of defense staff, etc. Because if the president moves, everyone moves. And a final point here at page 40 of the judgment. In Exhibit G7, a transcription of the meeting between Dr. McPalm, PW3, and A3 held on 26th of April 2019, extensive discussions of what charges would accrue to the people to be recruited. 50,000 each for about 20 people, and the need to test some of the weapons were held. There was even a statement made by Dr. McPalm that, quote, "If we are successful, then money shouldn't be a problem," end quote. So, thank you very much for making time to join us. I wanted to share a part of the 96-page judgment of the court with you, and I've explained to you why 3 people were escaped. Now, Honorable Yunus Afseni, having begun by this reading of the portions of the judgment, and I did it deliberately, do you share the opinion that this was not something worth the attention of the state?
First of all, let me again put on record that it has come to my attention that you were one of the witnesses of 4 ACP Agbojo, and that your contribution played a very significant role in establishing his innocence and his acquittal thereby. And so that is what is expected of a dutiful, responsible citizen of the country. The whole case, and we as lawyers, we talk of plausible cause. Was there some level of believability in the evidence adduced against the accused persons, such that a court of competent jurisdiction will come to the conclusion that a case had been made out against them? Or, to put it in another form, did the accused person raise reasonable doubt on the credibility of the evidence adduced against them, so that the court could err on the side of caution? Now, it appears to me that what you have read and the decision of the court was to the effect that 6 of the accused persons had evidence that clearly showed that they were involved in a criminal enterprise at overthrowing the Constitution, usurping the provisions of the Constitution, and particularly Article 3 of the Constitution. And that being so, the court was left with no option than imposing the sentence of death on them, and that is what the Constitution prescribes. Now, I have said, and I've said it at various platforms, that this doesn't sit well with our knowledge of coups, the facts surrounding the coup plot doesn't, I mean, it's not on all fours with what we know about coups. And so many people, and particularly journalists, when the news broke that some group of people were attempting to overthrow the government and had cutlasses and pans and whatnot, I mean, people simply could not believe that anybody in his right frame of mind could be attempting to overthrow a government with a cutlass. But what you have read convinces me to some extent that there was detailed planning on destabilizing the constitution. And I have said as well that even if they had succeeded, we would have resisted them. Because you see, our constitution, the 1992 constitution, established a principle of never again will we as a country want to live under a military dictatorship. And that no matter how useless, reckless, incompetent a government is, we will wait our time to vote that government out. We will not surrender our rights to determine the leadership of the country to any group of military insurgents. And so, and the case also establishes the principle that it doesn't really matter the crudity or crude nature of the weapons, but the intention to destabilize the country is what matters. And the steps, the actus routes that were taken for the purposes of achieving that intent. And that was clearly captured in the judgment of Her Lordship Ifya Sewa. Because, I mean, many people have said, well, these people and the way they went about it. I mean, I have sat in the class.
So Justice Ifya Sewa Asare Boche,
yes,
Justice of the Court of Appeal, sitting as an additional High Court judge, presided over a panel, including Amaliboba, Justice Amaliboba, who is also Court of Appeal, and Justice Stephen Opong, who is also a Justice of the Court of Appeal.
Yes. So and that's a High Court, but in treason cases, the High Court is constituted by 3 judges, and so we need to get the people to understand that look. But this is a High Court. Why were they 3 judges? Because of the gravity of the offense.
Right.
And so yes, Justice Ifya said that. Again, it baffles and confounds many political watchers who plans a coup d'etat on a WhatsApp group. It's not the notion of a secure WhatsApp group. It's a phantom. I remember the case of the British teenager who insulted Obama while sitting in Britain. He was fished out and dealt with by the authorities in both Britain and America. So you can't hide under a WhatsApp, and no one should delude himself into thinking that a WhatsApp group is so secure that your conversation is not known. I mean, the conversation goes to a device, a platform, and that platform is controlled by somebody. So people clearly will know. And in our jurisdiction, we know what happens. I mean, what happens? We bought equipment from Israel also. So we know what happens. So don't delude yourself into thinking that. And in any case, no one should think that the answer to bad governance is a military coup. The answer is actually waiting the term of the government to throw it out, or using legal processes like impeachment by Parliament of a president who is not working. Now, Agbojo's case, and I've listened to my friend and colleague, Martin was my colleague when we were pursuing the LLM, carefully, and he appears to, and even your narration of the events, scale of events, clearly shows that they appear not to have enough evidence against Agbojo or Abubakar Sadiq, or what was his name? That Seydu Abubakar, that signal man, or the guy who accompanied, the soldier who accompanied his friend, and sat far away, removed from the conversation. The fact that he was there clearly didn't mean that he was a participant, because his activities demonstrated clearly that he was not a participant.
And that was the only time. There were several meetings. He was not in any of them. So all the videos that were produced, he was in none of them.
So again, that is, the court should be commended for looking at that carefully. Say, look, let's not mix up the facts. Let's not create the impression that you can be found at a place where a criminal activity is to take place. But that doesn't mean that you are part of the criminal enterprise. And I think that is also commendable.
Of course, in respect of Colonel Samuel Kojo Gameli, they also found out how it is his subordinates who was connected in the matters, who mentioned him, and that's all.
That's all.
In addition to the fact that there was a WhatsApp exchange between him and a nurse at the hospital.
And so you see that those three people were rightly, in my view, acquitted and discharged. And the case of Agbojo is very, very sad. Now, it appears that, and I've heard him, the thing is that the whole debacle started from somewhere else and not from the investigative authorities. And that some person is responsible for drawing him into...
He mentions the defense minister because we were on a platform where the defense minister is, and he says these comments came up, and he repeated this Arab Spring thing, and the defense minister got offended. He believes that that is what triggered everything.
Well, so Agbojo was being drawn into the plot for a coup d'etat in this country based on the vociferous nature of his condemnation of the systems that operated in this country. But that is not what happens in democracy. In democracy, Samson, I've heard you, I've listened to you. You speak your mind. If the thing is wrong, it's wrong. You might be wrong, but you are free to express that opinion, even if it is wrong. Okay? And that's what we must all understand. And that's how governments are expected that's not how governments are expected to respond to criticism. Because criticism actually are intended to shape the government to deliver on its mandate. And so for me, it's worrying. It's very, very worrying. The people have indicated, the 6 other convicted persons have indicated their intention to appeal. And that are the processes of the law.
That's right.
To appeal to the Court of Appeal. They believe that the weight, the Supreme Court, they believe that the way the decision was done and the weight put on the evidence does not support the conviction for the crimes they were charged with. And so we have to await the decision of the Supreme Court on whether they will take a step at all.
Right.
Again, I have been to the condemned cells. I don't know when you were in Lagos, did you visit the condemned cells?
Yeah, when we were in law school.
Oh, when we were in Lagos.
I had done that before I came to law school.
As a journalist? Yes. Yeah.
And also at my LLB,
yes,
my project was on pre-trial detainees, 10 convicted prisoners.
Yes. Did you work with the Legal Resources Center at a point?
I contacted them.
Yeah, because that was when I was working for them. That was the work I was doing. Okay. You went to the prisons and saw a lot of people who had been remanded and were spending many years in detention when they had not been convicted of any offense. So, the former Chief Justice initiated a program.
Yeah,
George Nawood, and that was in furtherance of the things that we had done at the Legal Resources Center. So, if you visit, and Mensa Bunsu, when she was teaching criminal law at the University of Ghana, made it a point that first-year students should visit the prisons and understand the dehumanizing circumstances under which prisoners live. And especially since most lawyers will tend politicians. She was damn right. I mean, most of us have 10 politicians said no, that we had to invest in the prisons because probably that will be our final destination.
Anyway, Martin.
Yeah.
Congratulations are in order. And we understand that you are lacing your boots again to take certain steps to repair what your client may have suffered. But on the whole, would you say that he was misled?
So he even was not told anything about the coup d'etat. So I don't think misleading can even come in.
No, he was told when they asked him to join the group, the platform.
Okay.
He asked for to know their background.
Yes,
and they said they are involved in supporting vulnerable people, medical outreaches. And of course, he's a medical doctor with a hospital, right?
Yeah. Okay, to that extent, yes. To that extent, yes. But as you said, to the extent that when he joined, nobody ever discussed the coup. That's how come I'm saying, okay, then he wasn't misled. And actually, let's even mention this. The coup, as you rightly stated earlier, sometimes it's good to repeat because the facts are many. The alleged coup, because I can't condemn them, was discussed on the executive platform. He wasn't there.
That's right.
You see what I was saying? Mislead.
A3 set up the executive platform sometime in 2017. And then he put some people there.
Yes.
It did not include Benjamin Agojo.
Excellent. So he had no knowledge at all about a coup. But it's good that he spoke his mind. You see, like you stated in your introduction before going on to the facts, this is a case that vindicates Article 21 of our Constitution. That Agojo has said it over and over that, listen, the police council is not independent. The police is just an appendage of the president, right? And then he goes on to say Arab Spring. And like you rightly say, Arab Spring, you know, we voted for President Coup in 2016 because he preached Arab Spring. It's Arab Spring. What is it? That when he started in Tunisia, how did the young man emulate himself? Because he said there were no jobs, right? So they didn't have jobs, and so they couldn't earn a living to pay their bills. And that's the same thing. You find a Kufado, I have them on my phone. You find him sitting at Peace FM and at Arab Spring, Abo, Abaini Timinye Juma Man Mebununo, and what, Muntumami. And then Baumia will respond, and there will be jobs, and jobs, and jobs. And that is what we voted for. And he will turn the economy in 18 months. So for Agojo to write on a WhatsApp page that the conditions are ripe in Ghana for an Arab Spring, he had said nothing. He was just stating the obvious. And you see, Honorable Fusteni mentioned earlier, this right to free speech. It's not Voltaire, that great philosopher who was noted for saying that I may not like what you say, but I will defend you to death for your right to say what you like. I may not like what you say, but I'll defend you to death for your right to say what you like. Come on. Ekufado, you preach Arab Spring. And that is the message we all bought. We all thought that Mama was so corrupt. And so you would come and do us right. And that's why we voted for you. You come out and you turn out to be more corrupt than Mama. Far more corrupt. So Agojo is being vindicated. This is a vindication of Article 21. The right to freedom of expression. That's free speech. And the right to what? Freedom of assembly. So the freedom of assembly part is where he was given the tag, Take Action Ghana, guidelines that, if you want to do a demonstration, notify the police 5 days ahead of time. And that's the law under the Public Order Act. Is it 494? Okay, but at least Public Order Act, right? So what did he do wrong? And then he said, yes, you also need a speech. Then he found a speech online and forwarded it. The prosecution went to court and said, Agojo drafted it when they had no evidence. He said he contributed 2,000 to a coup d'etat when they had no evidence. Before we proceed further, it's sometimes good to read. Article 21, it says, all persons shall have the right to A, freedom of speech and expression, which shall include freedom of the press and other media, freedom of thought, then let's go D, freedom of assembly, including freedom to take part in processions and demonstrations. So what did he do wrong in guiding citizens that this is how to go on a demonstration? You see it.
So you see, he's done nothing wrong. So for me, this case is a vindication. Now, you also mentioned the issue of lacing our boots. Yes, you know this case falls within the matter of malicious prosecution. So we are analyzing it to see how we can make up such a case, put such a case before the courts. Because Godfrey Dami from day one knew that there was no case, against Agojo. But he was creating a storm in a teacup. Agojo and Gamele were added so that this will be reminiscent of the coup against Kwame Nkrumah, 1966. Military coup police intervention. Yes, in the 1966 coup, the military and the police that came in. So Godfrey Dami was just looking for, he sought to create that kind of, what do you call it, recurrence. That, once you heard there are soldiers and you see there is police, then that must be a very, good coup, so to speak.
But the Attorney General Dami was not the investigator. He was not the BNI people who investigated this matter. Now, and to begin with, you said the president is far more corrupt. We don't have...
the statistics in the last 3 years.
No, we don't have evidence
43, I'm coming. 43,
we don't have evidence that the president has done...
Has been
involved in corruption.
Investigation in lands. Samson, over 500 million. The president authorized that fumigation where there was no basis.
So now let's go to my substantive issue.
One more case.
My substantive issue is this.
We'll prosecute President Kufuor under Article 57.
That Attorney General was not the one who did the investigation. And when you go through the evidence that was put and that led to the conviction of the 6, does it not appear to you that what the prosecution did, as far as the 3 others who have been exonerated are concerned, was reasonable? Agozo was not on the executive platform. That is monumental and helpful for him. He was not in the country. He was not in their meetings. So that was good.
And he's consulting you and you coming to testify, also very critical.
But he was on other platforms of the same Take Action group.
Ghana.
Under the belief.
Take Action Ghana.
Take Action Ghana. Under the belief, as he tells the court and everybody, that this was an NGO doing good things. So, was there not reasonableness in adding him and the others?
Absolutely not. Absolutely not. Look, listen, ask Godfrey Dami. Godfrey Dami can't look me in the face and tell me that there was a case against Agojo. No. He and I, he knows. He knows. Godfrey Dami, if he was here, he can't look me eyeball to eyeball and say, Martin, there was a case. No. He just added. You know that book, Political Science, Machiavelli, The Prince. Yeah, how to keep power. So it was just to brew a storm in a teacup, creating, once he added Colonel. Hey, Colonel, Charlie, that's quite senior enough. And then an ACP. You see, Assistant Commissioner of Police. From ACP, you are going to DCOP, 2 more steps, and then COP. That was all that he did. I'm telling you that Dami knows between us. There were conversations. Even Agojo was standing behind me. Agojo head. Dami knows. I'm telling you, eyeball to eyeball. Dami cannot tell me that there was a case against Agojo. Don't play. Listen, you know what? Yesterday, coincidentally, I was reading the Olenu Commission report into this import licenses, what Trade Ministry was trying to do.
Yeah.
And so I'd been thinking about, you see how citizens came and gave evidence against ministers. There are many of them. I even forgot to bring this book, Murder in Colonial Ghana, the case in which the royals in Achim, Ochihini's house, the royals, the Abontindom Hini and the others in the royal family came and testified against their own kinsmen for the murder of Achia Mensa Apedwahini to accompany Ofuriata the first. They cut his head and put in the coffin so that, those days when she died. And that wasn't the first time. When Dokua was a queen mother in Achim too. When she died, they did the same thing. So when it happened in Ofuriata's case, the colonial government said, no, not a second time, and they investigated it. The point I'm raising here is that, Sam, we don't go enough into our history. So the young people don't know. People 50 and below don't know that much history. They've forgotten. It looks like we are all trying to make a living. The point I want to make is that, look, listen, people have stood up and testified against their own brothers and sisters. And so, the Achia Mensa case, they were executed. Those people who were executed, their sons and daughters are in office now. They are in the presidency. They are all over. So if you know the history, you know that, listen, people within the royal family in Action, over there, they testified against themselves and they were convicted. And a number of them were executed. The rest were saved by the delayed taxes, etc. Then you come to the Oleinu Commission report I'm talking about. You see the Jantua case. You see Kwesiama, the Minister for Trade, taking bribes. So many people. Azar. The list is endless. Nkunsa was a deputy minister of, a deputy speaker.
What's the point?
My point is that citizens have not been
Must be emboldened.
So Dami knows.
Yeah.
Dami can't look me in the eye. So yes, I've been thinking about it. Should I say it? No, I'm telling you that Dami knows that he just added Agbojo just to give the thing a coloration, but not that his analysis of the facts show that this. And Agbojo was standing there. If you
let me bring in Professor PJ Tuya. And Prof, sorry to begin with you on this note. At least, I don't know if you have had the opportunity of the judgment and to be able to read, but at least for the portions that I have shared with you and how the court analyzed the evidence and evaluated everything to the point of exonerating the three, including Dr. Agbojo, would you not say fairly that there was a reasonable suspicion to bring all the three in? One, the senior military officer whose WhatsApp conversation was seen with a nurse at the hospital, and who was also mentioned by his subordinate when they had been arrested by the BNI, mentioned him, so they brought him in. Except they claimed during interrogation he had confessed that he knew of the activities. And then during the trial, they couldn't submit any evidence to show that he had actually confessed. Then the second one, Seidu Abubakar, whose friend, he says, led him to the next door beach resort, where his friend, who has been convicted, was in a meeting with one other who has also been convicted, and they were discussing Coup. And because of that association, he was also brought in. In respect of Agbojo, you will find that he was invited to join. He was not in the country, all right, but he was on platforms other than the executive platform, which, according to the process, was the platform that was used to discuss the things about the manufacturing of the local guns, bringing in the young man to the hospital's laboratory, converted for the manufacturing, and the manufacturing was going on. They went to test these guns out there. They were testing the bombs. They wanted to test the bombs. And there was a conversation about whether the trigger is or remote controlled or what. There were the sketches that were made, of a map about important installations. There was the conversation, this is videotaped, of the conversation about capturing the president, the vice president, and all of that. To the extent that he found himself with one of the WhatsApp platforms under the belief and the knowledge that it was for good purposes. Would you not say there was some reasonableness in adding him?
Samson, thank you for having me. I think that, yes, there is some evidence that on the face of it triggered the need for an investigation to be able to determine the extent of the evidence available and the extent of involvement. And so that is normal for any prosecution to conduct its case. So at the end of the day, the nature of the evidence you get and how you can connect them you can put the pieces together before you can determine if you have material to be able to charge leveled against any of these persons who were involved in the case. for me, as you know, in criminal cases, you have to establish your case beyond all reasonable doubt. It's on the part of the accused person just punch some loopholes here and there on the grounds of establishing that there's a reasonable doubt to be able to exonerate him or herself. And so I think that I had the opportunity to look particularly at the portion that touched on Dr. Gozo, and I realized that the evidence was very weak, and the prosecution could not establish the accusations and the statement they made against Dr. Gojo. For example, at the point you say, "I don't recall, I don't remember," and so
that's when they were trying to establish that he was on the executive platform, and they couldn't. They were just saying, "I don't recall, I don't remember," and that was very bad.
That's right. Yes. And then donating $2,000, 2,000 cedis,
right? Not
even dollars, to support a coup d'état, and the other one writing a speech to foment an Arab Spring. I think those evidences were very weak and they were not supported. So, in my opinion, that should have led to the conclusion that, especially Dr. Gojo, no charges should have been leveled against him because the evidence was certainly weak. And that is why there is room for speculation that there could have been other factors which could have caused him to be added to the list of the accused persons.
Why do we say this?
To find a way to have him incarcerated.
Why do you say this for only Agbojo and not the two others? I'm talking about the senior military officer Samuel Gameli and also the corporal Seidu Abubakar, who only visited with a friend to one of them just once and didn't even participate in the discussion. Should he also have been added? The military man who also was only mentioned by his subordinate and a WhatsApp conversation between him and a nurse in that hospital, which doesn't bother on that subject. Should they also have been added?
Not at all, not at all. I was coming to the other two as well. In all these cases, the evidence was very weak, and that is why, excuse me, by extension, not just with Dr. Gozo, but in the other cases too, they were very weak. And so it is gratifying to note that the judges were able to conclude that they should be acquitted and discharged. And so again, but among the three, we know that Dr. Gozo is the one that is most well known and for his advocacy and his to express his views of how the police system works and governance issues and so on. And so, just like yourself, I've also had the opportunity of working on a number of projects, and I know where he stands on certain important national issues, governance issues, and so on. And so, I think that at the end of the day, in my opinion, it borders down on attempts to violate certain rights of the Constitution, which, speaking for Dr. Gozo in particular, I would say, especially freedom of expression and freedom of association, freedom of peaceful assembly. These are issues which he tried to express them, exercise them, but he was found not to have the rights or the power to do that, which is very unfortunate because we live in a democracy, and with these rights guaranteed us in the Constitution, we should be able to be vociferous, be vocal and critical of the government. And that is how democracy evolves and develops. And so,
Prof, this
to have been gagged,
Prof, this would have been
to attempt to gag him.
Prof,
this related to this matter.
This would have been the third treason matter within this regime, President Akufo-Addo's regime, if my memory serves me right. Kwaku Aiyedoro, and then Oliver Barker-Vormawor, and then this group. When you make a comparison of all of this, and I know you have been very vocal against the ones, for example, against Oliver, that he made a comment on social media, and that is enough. to be putting him before court, truncating his, illustrious career and life, in his studies. Don't you see a clear difference that this, at least, there is some serious material talking about the manufacture of the guns, all the bomb issues? This was a case in comparison with the others.
Yes, I know that this issue has also been raised, that Dr. Gojo, as a police officer, could have sensed something. There should be some intelligence that he could have sniffed that there's something going on here which I think is beyond the ordinary, that I should have noticed. Yeah, so for that, on that part, I think probably could have done a better job in terms of knowing that there was something beyond the ordinary, and so he should have questioned more, But we can see that he did some initial investigations or some information which indicated to him that things were, there's an NGO and related to medical issues and so on, humanitarian matters and so on. So I think that in that respect, he was safe in deciding to join the group. But where I might find fault with his continued engagement was the fact that as a police officer, he should have sensed that something was not going right. Having said that, though, I think that it isn't his task to prove himself not guilty. It is the task of the prosecution to establish that he was actually involved in doing those things.
All right.
If they could have said that as a police officer, could have sensed something going wrong, even if he claims that he didn't know about it. That should not be the basis to say that he should be charged for abetment, and the court should have found him guilty on that.
Right.
So I think at the end, it was more based on his other activities, which gave them a ground to connect him to the case.
All right. The court concluded on his matter and said that upon a charge of abetment, where intent or requisite mens rea of Dr. Gojo is necessary to establish the crime of abetment, as already stated, we find that the prosecution has failed to establish that he knowingly or purposely offered assistance to or encouraged Dr. McPalm in his attempt to overthrow the Constitution of the Republic of Ghana through the removal of the executive and the president from government by violent means. It came to a few other things and said, upon the foregoing, this court finds Dr. Gojo not guilty to the charge of abetment of crime, namely high treason. Accordingly, he is acquitted. Now, let's go to the phone lines and speak briefly to the Attorney General, Godfred Dame. Thank you for joining us. And one of our viewers watching us from Germany sends this message, and he says, I am not a lawyer, but upon the benefit of the little portions of the ruling you have shared, I will say that there was reasonableness in adding them, that is, the three who escaped, in adding them to the investigations, but completely unreasonable to add them to the prosecution. A sound investigation would have revealed ACP Agojo and Colonel Gameli's complete lack of knowledge of what the others were planning. That's why it may have been reasonable to investigate them, but unreasonable to prosecute them. What do you say to such a view for A5, A7, and A10?
Your listeners, I think last Wednesday, I had very mixed feelings in court. The mixed feelings stems from the fact that, first and foremost, I recognize that Ghana is a model for democracy and constitutionalism in Africa. And that is why the duty to preserve the status of Ghana as a constitutional republic rests upon all of us, and the Constitution has deliberately, in its opening provisions, created the offense of high treason and actually specified punishment of death. The reason why I had mixed feelings was that, indeed, I was thrilled by the historic defense of the Constitution, in that I had, with all respect, secured the conviction of 6 Ghanaians who are systematically and deliberately orchestrated a plot to overthrow the government. But again, I was also saddened by the realization that these gentlemen and a woman were going to face the ultimate punishment of death. And for me, that is what is of prime concern to me, and that's what I sought to engage the public. Of course, I can understand the obsession of the media with ACP Agozo, because indeed he's one person who has made himself a media star. And following the acquittal, he has made all kinds of comments, some of them clearly casting aspersions, not only on my integrity, but even on the integrity of the whole prosecution team or the office of the treasurer. And I find it very, very ridiculous, with all respect. First and foremost, it is important to note that it's not only ACP Agozo who were acquitted. 2 other persons were acquitted. They have been lost in the scheme of things. Of course, that's the lack of ACP Agozo. He wants to make himself a media star. I refuse to respond to comments which border on plain insults. There were plain insults, abuse, and all that held on me by ACP Agozo. I refuse to comment on it. But I'll, however, say that it is very important to note that the court, upon the close of the prosecution's case, found that the case had been made to answer by ACP Agozo. The holding by the court that was a case for him to answer clearly affirmed that the prosecution prima facie had led evidence that reasonably warrant a conviction unless the accused person made a response which cast reasonable doubt on the case of the prosecution. So that clearly shows that the prosecution of ACP Agozo cannot, by any stretch of imagination, no matter the antics that any person may resort to in the media, can be characterized as a very frivolous one, or a malicious one, or an unfounded one. Indeed, the evidence against ACP Agozo clearly showed that he offered pieces of advice to Dr. McPalm, who was the first accused, to replicate Arab Spring demonstrations in Ghana. I'm not really the kind of person who takes the media often. Indeed, I had never even heard of ACP Agozo until the docket came before me. I had never heard of any comments by him in the media at all, whether he was inciting people to go on demonstrations or guiding them out. I didn't even know him. I'd never even heard of him until the docket came before me. And my duty as a prosecutor, with all respect, the person vested the prosecutor authority in the Republic and also enjoined to ensure that the security of the nation is kept intact, is to ascertain whether, on account of the docket that had been built, there were material that would warrant a prosecution. And I'm saying that clearly the holding by the court that there was a case for him to answer after the prosecution had closed his case justified the decision to charge him. Now, the case against him was not only just that he advocated a replication of Arab Spring in Ghana. Indeed, there was clearly evidence that he held meetings with Dr. McPalm, and we all know that Dr. McPalm was the chief architect in this. The guilt of Dr. McPalm clearly would have been established because all the activities of the 6 persons who were found guilty were on the strength of the scheme or the mechanism that he had built. Beyond that, he actively engaged Dr. McPalm and other persons and actually even offered money to support him in those activities. So the finding by the court at the close of the prosecution's case was that he indeed, I'm referring to ACP Agozo, had a duty to explain to the court why he engaged in all those activities. Extracts from his first half conversation show that he participated in not only one WhatsApp platform that had been set up between the group, but 2 WhatsApp platforms. He was a member of the Take Action Ghana General Platform. He was a member of the Take Action Springboard Platform. And when he opened his defense, then all these matters relating to how he was not part of the Take Action Ghana Executive Platform then came up in evidence. And clearly, this is reasonable doubts that he had raised. Because indeed, evidence was laid at the trial to show that the very sensitive discussions relating to orchestration of a coup d'etat occurred on the Take Action Executive Platform. So the many justices of the Court of Appeal who were sitting as additional High Court justices rightly held, in my view, rightly. And indeed, whilst I was sitting in court listening to a judgment, it's a matter of record that I told the DPP, together with my Deputy Attorney General, that in fact I would actually be pained if Agozo was found guilty. And that clearly, for me, shows integrity. And I say that the conclusion by the court that he was not guilty of the offense, together with it's not just only him I'm concerned about the 2 other persons who were also acquitted. For me, attested to the strength of the integrity of the judicial process in Ghana. And that's what must be applauded. But any suggestion by any person, court-headed, and who wants to raise unnecessary controversy or cast aspersions on my integrity, that the prosecution was unfounded, was frivolous, clearly will be baseless. Utterly baseless. Because the court found that he had a case to answer.
Yeah, so in the discussion generally here, and because I was deliberate about something, because I took my time to read portions of the judgment, and you would hear Honorable News Officer begin his commentary by saying that because of what I had read, he took a view that this was a serious issue, rather than the initial attempts to mock at what had been going on. But I think the issue now here is, you say, for example, that whilst you sat in the courtroom almost 4 hours listening to the judgment, you felt that it will not be good for someone like ACP Agojo, that is A5, A7, and A10, who were exonerated, to be convicted. The question being raised is that you should have seen this before the prosecution.
Not at all. Not at all, because I made the point that, yes, the prosecution led evidence to show that was a reasonable case for him to answer. And that's the most material point. The duty of a prosecutor is not necessarily to secure conviction. The duty of a prosecutor is to ensure that a person who is reasonably suspected of the commission of a crime is brought to court and for him to answer to the charges leveled against him. And the duty of the court, of the prosecutor, when he appears before the court, is to marshal evidence that will prima facie establish a case against the accused person. And if the accused person, when he is called upon to open his defense, is not able to cast reasonable doubt on the prosecution's case, that person will have to be convicted. So really, the prosecution had discharged its burden to the Republic of Ghana, and the duty to the Republic of Ghana in this situation was very onerous, because I've already spoken about the duty on all citizens to preserve the status of Ghana as a constitutional republic, and the fact that the Constitution places an obligation on me, with all respect as the Attorney General, to ensure that whoever is engaged in any scheme that, whether by himself or in concert with others, that leads to a destabilization of the constitutional establishment of the country, will have to be put before court for treason.
What do you...
Please hold on. So the point is that we had reasonable basis for putting him together with all the other 9 persons on a charge for treason.
All right.
The reasonableness of our decision was upheld by the court.
Right. What do you say?
Go to the prosecution case as a case for him to answer.
All right.
He was able to establish doubt and therefore had an acquittal. If I were him, I would be going to court. I was going to church and to thank my God.
Right.
Rather than making all these wild statements about the prosecution being frivolous and all that.
Okay.
These are wild allegations that I refuse to respond.
The next thing I wanted to find out from you is this one. That there are some who say that, the soldiers that were being recruited for this purpose.
Yes.
They were to be paid 50,000 each and so on. Now, some were recruited and rather were the ones who, somebody would say, led these people on. So it's like what you somehow would say about some of the work of an ass, sort of an entrapment. That you intentionally put these soldiers in there to lead them on, so you arrest them and prosecute them.
No. So the distinction is quite clear here. In respect of cases that we saw in analysis, investigations, and all that, was a case where clearly there was a deliberate scheme to put the persons in those situations. To create a situation with the expectation that the person will fall victim or prey. In this case, there has been deliberate schemes by persons themselves. They themselves were orchestrating to act in concert to overthrow the constitutionally elected government of Ghana. And they have gone ahead to devise various schemes of how to kidnap the president, abduct the president, spray some chemicals on them to ensure that they fall into a deep sleep, or if that's not successful, to shoot them. And they have even set out maps on how to get to a Jubilee House and how to destabilize various communication equipment to destroy, various communication devices in the country. So there was that deliberate plot. And they knew that taking over the reins of government by force of arms could not be successful unless there was involvement of the armed forces. So they went out to recruit various soldiers to be part of the scheme. Some of the soldiers remained part of the scheme to the end. And those were the ones that we found guilty of the offenses. About 3 or 4 soldiers were found guilty and sentenced to death.
All right.
And then some were also good citizens and came to report their superiors. So the military intelligence then cleverly sought to record their activities and all that. That's how we came by the evidence. That's why I say that by the grace of God, were it not for the grace of God, we don't know what would have happened in the country. Because clearly we would have just woken up one morning and then this would have happened. So really, this was a very serious trial, and indeed, as we note, is actually the most successful treason trial in the history of the country.
Okay.
Even in the State versus Oxford, which is the only recorded case of treason, 1983.
Yes. The court noted that
only 2 persons were convicted. 5 persons were put on trial, 2 persons were convicted, and 3 acquitted. And of course, I did not have any history of the acquitted making noise and casting aspersions on the integrity of the judiciary as well as the prosecution, as we see in this case. And in this case, 6 out of 9 persons were convicted. Indeed, it would have been 7, were it not for the unfortunate death of Dr. McPalm. Yes, clearly, as the judgment shows. So this was actually a very successful prosecution, and I think the records reflect that. And in all of this, my major concern, which nobody has actually vetted his mind to, is the security of the state attorneys who were involved in this prosecution. They have conducted many high-profile criminal cases, from treason to murder, secession, galamsey, corruption, various financial crimes, armed robbery, kidnapping, and indeed all kinds of the republic. And these are activities that secure the peace and territorial integrity of the republic. All the security they have, nothing.
Of course, the security of the judges too.
They do not enjoy any protection at all.
Of course, the security of the judges too.
Yes, precisely. And that's what we should be concerned about. How do we secure the security of these people who do all these cases?
All right.
Yes, in the Republic of Ghana.
Godfrey Yeboah-Dame, Attorney General, thank you very much for agreeing to speak to us briefly. Thank you so very much. And yes, so we want to move on to the OSP and running away from Cecilia Dapaah or not. You want to make a brief comment? A minute? Yeah.
Yes. The number one, look, Alfred Dam is just playing to the gallery. He started on a note that he's saddened that these guys are going to suffer the death penalty. Since 1993, nobody has executed any person convicted. There's not the slightest chance that these guys are going to be executed. Not in the context of...
You can't take how he feels from him. That's how he
It's
feels.
just a way of
That's how he felt.
appeal to emotions. That's what I said.
I don't think it's fair to him.
Oh,
I don't
that's
think
the
it's
way
fair to
I
him.
see it. Because it's as if they are going to carry out the executions tomorrow. The guys are going to appeal. By the time even the appeal is that he or Dami would have been out of the Attorney General. He'll be out in about 10 months' time.
Well, there's no
right?
guarantee that appeal will be successful. So let's.
Yes, so
for now, this is the verdict. This is the judgment.
People's emotions as
Okay.
if anybody is going to carry out any execution. In 30 years, since 1993, nobody's been executed and nobody will be executed tomorrow. Don't deceive the public.
Right. Okay.
That's one. Then number two, he's saying they had reasonable cause to go ahead with the prosecution. I was at the BNI with Agojo. I helped him to make his statement. The statements were there. When he read the prosecution's case, didn't he read Agojo's statement? It showed poor judgment.
Did you make a submission of no case before the court?
Yes, we did.
Did you succeed?
I didn't, but that's not.
So
an
that is
indication.
that is central.
Oh, no.
That the court disagreed with you saying that Agbojo doesn't have a case to answer.
Oh no, I don't think so. It was
Three judges said he had a case to answer. So it's not only the Attorney General who felt he had a case to answer.
You see, these are allegations. The investigation was poor on Agbojo. Simple. Where the coup was being discussed, all you had to do is take the WhatsApp thing, check what's Agbojo there. Simple investigation. Such wishy-washy investigation on Agbojo, and he's paid dearly. Like this case is going to be an albatross
just a minute.
The rest of his legal career.
Yeah.
Such poor prosecution
the
of this
little
case
comment I will make
on Agbojo.
What has made Ghanaians not given this case the attention that it deserves appears to be the sloppiness of the investigation.
Sloppiness?
Yes. In terms of the
investigators who have successfully secured
successfully
secured the conviction of 6.
No, in case of
that's not sloppiness.
In the case of the 3, in the case of I didn't complete my sentence when you jumped in. In the case of the 3.
Okay.
Now you see, when you mix weak cases with concrete cases, you dilute the gravity of the matter. And that's what came out. I mean, we are now beginning to appreciate what went into the...
So what do you say? That those 3 made a submission of no case, and they were told that a prima facie case has been established against you. Come and answer. And they answered. That's how I got them out. Without that, they would have gone in as well.
The judges were minded to give the prosecution the benefit of the doubt. Because
okay.
It's a serious offense.
Professor PJ, what will you say in a minute to wrap up? Hello, Prof.
Hello.
Yes, what will you say in a minute as your concluding comment?
Well, I think that you were asking about the reasonableness of the investigation.
Yeah, after listening to the Attorney General, yes, what will be your concluding comment?
Okay, I think that the Attorney General is acting as the Attorney General, and I think that he has done his job. He's supposed to get the prosecution, take up the matter before the court and to secure a conviction. Following that, it didn't work out, and he's hailing that as respect for the rule of law. But I think that I come back to my point that with respect to the 3 who are acquitted, I support the view of Mr. Husseini that the investigation was poorly done, and there wasn't enough to establish that they needed to have been charged and to be involved in the prosecution of this matter.
Okay, thank you very much. And you have heard about high treason, you have heard it over and again. What exactly is it? High treason or treason? What is it that you will do that will get you into trouble for this particular offense or charge? Join me tomorrow, God willing, on my favorite show, my weekly legal clinic, The Law. And we are answering the question, treason, what is it? And thankfully, we are engaging 2 lawyers who were also in this case. Lamteg A. Apanga, his managing partner, Prestige Partners, and Victor K. Adaudu, his managing partner, Lord and Lords Practice Limited. Tomorrow we take our time and dissect it. What is treason and its various forms? What can you do to stay away from it? We'll be right back on OSP.
The office discontinued its application that was pending before the High Court for a confirmation of the seizure and freezing orders in pursuance of the referral of the case to Yoko. The court ordered that the office should return the cash sums and defreeze the accounts of an investment of Ms. Dapaah within 72 hours. The office also discontinued the procedural criminal charge against Ms. Dapaah for failure to return forms on declaration of property and income, since that was mounted on the original application for confirmation of the seizure and freezing orders, which was discontinued earlier in time. The office has had the benefit of 7 months of in-country and 4 months of collaborative transboundary investigation. Members of the press, on the totality of the gathered evidence and intelligence, it seems to us that the case is largely in the province of suspected money laundering and structuring. By operation of law, the Economic and Organized Crime Office, IOCO, has a specific and direct mandate in respect of suspected cases of money laundering and its attendant activity of structuring. Of the special prosecutor is referring the case to IOCO for continued investigation and further action. The office will be in close collaboration with IOCO and continued collaboration with the FBI.
Right, so you've heard it all, and there was a court date, and the OSP went to court and said, I want to withdraw the cases that I have against Madam Cecilia Dapaah. Well, he got the cases withdrawn, but the OSP was instructed or ordered by the court to release Cecilia Dapaah's monies and assets that have been seized within, is it 74 or 72 hours? What is happening to that now? But my guests in the studio here, Honorable Yunus Afuseni and Martin Kwebu, what do they make of the turn of events? There are some who say the OSP has wasted our money all this time doing all this investigation and then only come to this point and say, well, the thing I'm looking for is actually not there. So it's another institution that should investigate it. But they too insist that it is the work we have done that has led to the discovery of money laundering that we are giving to IOCO. Where have we come?
Sam, it's not bad. Yeah, I can start. It's not bad. Like I subscribe to the view that they have done some work that has brought us this far, right? So we shouldn't overly blame OSP, except that with hindsight, I think next time when there's money like this, we should all learn, because of the Supreme Court decision that even IOCO itself cannot investigate all money laundering cases. The Supreme Court in Ibrahim Malik recently held that if the money is not government money, IOCO shouldn't investigate and prosecute such a matter. So with hindsight, I think from the get-go, when you see plenty money like this, I think OSP in future should invite the police and invite IOCO onto the investigations. Yes, so that we don't lose time, because you see that we spent 7 months. Yes, he's done a lot of work, but the issue is that now IOCO too has to start not from straight away where OSP is, no, because they have to apprise themselves and all that. So it will take some time for them to come up to speed with the matter. You see, so we can avoid that by giving IOCO and the police some visibility on the case from the get-go, so that people are warming up on the sidelines, so that in the event that it turns out that the case is not cognizable by the OSP, then that institution will take over and hit the ground running, rather than now reading through and all that, right? Yes, so that is it. And I support, because we've done a lot of work, and look at it, Sam. You know, now the thing we should be excited about is, I see, on the money laundering charge, there's a provision that seems to say that, look, even if we cannot prove the unlawful activity, which Honorable and I have been talking about, the predicate offense, you're a lawyer, you also know it. You know, in money laundering, ordinarily, before you get a conviction, you have to show the crime, the unlawful activity that was engaged in first. before the person is trying to launder. So let's give a quick example. So you have to show that Mr. X stole, or Mr. X imported narcotics, or Mr. X did tax evasion. Maybe you should have paid 2 million to GRA.
So the source must be offense wrong.
Yes. And then, because of that money he got, now he's trying to trade. He's selling foods, he's building real estate, etc. So he's laundering that money. Good. But Section 1, Subsection 3 of the Act makes it clear that even whilst investigating, if the person is found with money, you and I, our favorite Article 286 Clause 4, of course, you started before I joined. If he cannot explain the source of that money, then that in itself too, the person must be convicted. Let's read it. It's very clear. So hopefully, in the context that Madame Dapaah so far has not been able to explain the source of the money, the information she gave, 3 sources have all failed. They've proven to be lies. It looks like we'll get her there. So this is what Section 3 says. Subsection 3. It says, where a person under investigation for money laundering is in possession or control of property which the person cannot account for and which is disproportionate to the income of that person from known sources, that person shall be deemed to have committed an offense under subsection 2. And subsection 2 is the one that says a person commits money laundering if he conceals money from an unlawful activity, blah, blah, blah. So it appears this one, you know, it was in the previous act, the 874, etc., that if you have money, you cannot explain the source, it will be taken from you, blah, blah. So that's its repetition here. So I think so far, Sam, you and I know there are OSP reports that have shown that Madame Dapaah said the 800,000, the one the house girls and go to, belong to her deceased brother's, her deceased brother. When lawyer William Kusi in Kumasi sought to represent the widow so that they will ask her for the money, then she backtracked. She now said the money is for her. So there's one lie on record, on the OSP records. 2, she said 2 cosmetic businesses. You know, OSP did a report. OSP had interviews with the owners and they searched it as Registrar General. Then it turned out those 2 did not belong to her. So far, in explaining sources of her money, Madame Dapaah has told 3 lies. So going into this trial, she has a huge credibility issue. The OSP report came out. We read it sometime, was it October or so? That's the information she gave. Oh, I got this I got this money from these 2 cosmetic businesses. Investigations proved that that was a lie. So when she goes into court, you know the rules we use in court. On 3 occasions, you've lied. So the 4th time, how will a judge believe you that this time your explanation is true? Okay, let's add this last one. Article 78 Clause 3 says that as a minister, if you are doing business, you need the permission of the Speaker. So Madame Dapaah, as far as our checks show, has not sought the permission of Mr. Speaker. It says, 78.3, a minister of state shall not hold any other office of profit or emolument, whether private or public, and whether directly or indirectly, unless otherwise permitted by the Speaker, acting on the recommendations of a committee of Parliament on the ground, blah, blah, blah. So Madame Dapaah doesn't have that.
On the grounds that holding that office will not prejudice the work of a minister and that no conflict of interest arises or would arise as a result of the minister holding that office.
Excellent. So Madame Dapaah has 3 false statements. So when she goes the 4th time trying to explain this thing, it's going to be difficult. And let's put this quickly in passing. Please, can Mami Tiwa address us that they've taken the money from Madame Dapaah or that they will be present at the time OSP is handing over the cash so that they immediately take it away? Because from the way the burden is being...
You just preempted my next question.
Okay. Please,
so that is it.
Yes.
So the concern is that the money is likely to be dissipated.
No, we'll not allow that to happen. And Madame Tiwa, so like we're saying, she and her men, or her, of course, naturally, not she herself, her subordinate, have to be present at the time Mr. Ejabin or his subordinates are handing over the $500,000 cash and the $2,730,000. They have to be present. Then they take, and then the Kinte and those things. Right, okay, or the Kinte were in the house helps case, right? So they have to be present. If not, if she takes it and dissipates it, no, we'll not forgive
And the accounts that had been frozen.
Excellent. And you know, Yoko too has the same power like OSP. OSP even copied from there. So it means that Mamitiwa by now, that one I trust that by now they should have done the letters to the banks that we have taken over. Please, these accounts are frozen. And then Yoko and Adia Act, they have 2 weeks, right, to go to court for confirmation of the... Yeah, so they shouldn't be dissipated. And we need to say, Mamitiwa, we need to remind her, people are saying it on social media that her track record in the past has not been good. She has sought to protect Akufo-Addo. So this one, she has to get it right. So this is her make or break case because they've recited the A+ tape. The tape is out there in public when she was begging A+ not to make the
That's
case.
a major concern of the public.
So Mamitiwa, please, don't try. Akufo-Addo has been shown to be corrupt. If you try to do this one, you are finished. Because the A+ tape is there. People will soon start playing it where she's begging A+ not to press the case against Asensu and Jinapo, that's Samuel, because that would make the government bad. And then you remember there was also the case of the Takrade girls, and then there is a case of Sewa Bruni. So 3 cases against you, Mamitiwa. This is your make or break case. Just separate yourself from Akufo-Addo and his corruption legacy. Separate yourself from these 3 past cases where you've not done right by us as citizens. Make or break. Last chance.
Now, listening to Martin, it further confuses me why the special prosecutor decided that this case is within the province
of money laundering, which he doesn't have power to.
We know money laundering doesn't have power, it's EOCO. But money laundering is not a standalone offense.
That's what he said.
Yes, it's a derivative offense. So there must be, I mean, even the Money Laundering Act makes that very clear. That money laundering must have been from an unlawful activity.
Yeah.
And that person must attempt to conceal or attempt to conceal the process of that crime. So, yeah.
Let me tell you, but I don't see the subsection 3 now saying that if you can't explain that, we should take.
So that is where they stand alone. So money laundering can be prosecuted as a stand-alone, but money laundering does not occur as a stand-alone offense, but can be prosecuted as a stand-alone offense where there is not enough evidence to support the source of that illegality, or where the predicate offense has been committed in another jurisdiction. Okay, so that is it. And when you look at the West African Institute for Financial and Economic Management, they've designated categories of predicate offenses of money laundering. Clearly. And I mean, and there are many.
We've also listed some in
the Act 79. In Section 79 of
1044. No, I'm talking about the Yoko Act.
Yes.
The new Money Laundering Act.
Yes.
1044.
Yes.
Unlawful activity. They've
listed all those things because they took inspiration from the West African district. So for me, I think that the OSP owes us a responsibility to tell us exactly what was a predicate offense. Especially, and I'm adding to Martin, when Article
286 Clause 4.
286 Clause 4 says that if
unexplained wealth,
if the process cannot be reasonably attributed to salary, loan, gifts, inheritance, then that process will be acquired in contravention of the Constitution.
Yes.
So when the special prosecutor investigated, when the special prosecutor decided to serve Madam Cecilia Dapaah with lifestyle audit forms, what was the prima facie case that compelled him to do that? It's precisely because Cecilia Dapaah was arrested in public office. She was a public servant, and that 82864 is conduct of public offices.
Right.
You understand? And so then it defeats the very purpose for the creation of the office of the special prosecutor. And it appears that we have come 360.
Right.
Because you see, let me explain. The MPP manifesto of 2016 said that the Attorney General and Minister of Justice failure to fight corruption was precisely because the Attorney General and Minister of Justice sits in cabinet with his colleagues, and so it's difficult to do justice to cases of corruption brought against ministers of state? Who has prosecutorial powers in findings against a person at the IOCO? Who prosecutes IOCO's cases?
Attorney
General will do that. So if the very reason...
They have their own lawyers.
Yes, but they do it under the fiat of the Attorney General. Under the fiat of the Attorney General. So that was why in drafting the OSP law, we had said that we had inserted in the law a provision that automatically gave the special prosecutor the power to prosecute without the fiat.
Now you also put consent there. You said on the consent of the Attorney General.
No, it's deemed.
But the language is
so. As we understand, the OSP doesn't have to go to Attorney General anytime.
Anytime
say, I have this case, I want to do it. I need yours.
But the language is weak.
Even with
let me get on the phone and thank you very much. I think this will be sufficient for now. We have our final issue and we have Professor Dr. John Osai Kwapon, CDD Fellow, joining us on the matter of the Electoral Commission contemplating November for elections rather than in December. And what a healthy thing everybody is saying for the NDC to be back to the IPAC. Doc, thank you very much once again for joining us. What's your take on this posture of the EC on this matter, and what you are reading from the parties as well?
Good morning, Samson, and thank you once again. I was reading about the rationale behind trying to move the election to November. Some of the reasons alluded to talks about civic engagement and getting people involved. There's the idea that you can also make it a public holiday. We don't necessarily have an issue with voter turnout in our national elections. Holiday or not, I think we do well by showing up to vote. But if it is still to encourage even a higher voter turnout, that's okay. I think for me, moving it to November reinforces and reiterates something that Professor Kweku Asare has been saying over and over again, that in the event that there is an election dispute, and it's in the event that the election has to go for a runoff, then you build in enough time to resolve all of those outstanding issues before January 7th, where the duly elected president or member of parliament is sworn into office. So on the basis of that, I think I believe that it would be a good idea to move it to November, if that is to cure some of those challenges you faced. Not that we are anticipating more election disputes, but in the event that time is needed to resolve a number of things before swearing in date, then that is fine to move the election to November. But if it's a question of trying to encourage more citizen engagement and voter turnout, I don't think it does much for that, because when it comes to presidential and parliamentary elections, we don't have a problem, showing up to vote. But again, if that becomes the law, then I think one of the issues we've been talking about is how you improve voter turnout in our district level elections. If moving it and particularly making it a holiday would encourage voter turnout at the district level, then I can see some benefits in to that.
That's the proposition. But Prof, we have been here before, where in fact the Attorney General, Maretta Brew, went to Parliament, and it appeared that both sides had agreed that they were going to change the election calendar to November, only for the opposition then to scuttle it. I think it was 2016 or 2014, right? So how do you look at the prospect? Is it going to happen really?
Well, let's see sort of what kind of consensus can be built around it. So maybe the circumstances may have been different in 2014. Maybe 10 years later, the thinking has changed, the mindset has shifted. and perhaps both sides will be able to see some virtue. It will be also interesting to see the kind of initial consensus that is built at IPAC. Dr. Farijan recently in his Constitution Day remarks, really talked about the critical role of IPAC in trying to, build consensus around some of these election issues. And that is why, for me, it is also very important, and I'm glad that the main opposition party, the NDC, has returned to IPAC, because I think being one of the two main political parties, it was very unfortunate. And yes, they had legitimate concerns as to why they walked out of IPAC, but I think their return to IPAC is critically important. They have a voice, they have important things to contribute, and so being present at IPAC as the parties try to work with the EC to build consensus around some of these issues, I think it's very important and a welcome decision.
Right. What do you say? Is this possible? And it coming at a time when the SDA Church, I heard you support that they had a legitimate concern and it ought to be supported. Do you see that this is going to happen anyway?
Yeah, I said they had a legitimate concern because of Article 21(1)(c), where one has the right to practice his religion, freedom to practice a religion and to manifest same. And that being so, they have a legitimate right. But whether we had appetite for that is another matter. And I said that clearly on the distance. In this particular case, and I agree entirely with Professor Kwapo, there is the reasons given by the Electoral Commission appear to be a non-starter. They talk about turnout, and our turnout has always been beyond 60.
So you do it on a holiday, then you improve it.
Well, and again, that's a fundamental, and I'm happy you're a lawyer, that's a fundamental responsibility. That's a fundamental matter, because elections are not a duty, they're a right. Okay? So everybody must have the right to vote. But you can't get punished for not voting. So again, they are wrong there. They are wrong in thinking that if we declare it a holiday, the turnout will go up. Because if nobody...
You make it easier.
No, it has always been easy. It has always been easy. Thirdly, there is no immediacy. In 2014, we thought that the 2019 experience of Ghana brought us on the brink of a constitutional crisis. We had a very limited transition period. And so things were done in a way that people clearly had issues. Now, so we thought that let's move it to November. In 2014, everybody appreciated the difficulty. But we were told, no, you need 2/3 majority. And that they were not prepared. The MPP then was not prepared to. But what is the immediacy? What is the problem now? What is the problem we're trying to deal with? Because turnout is good. 78% turnout in a developing country like ours is good. Okay? 2, you can amend the constitution based on a religious imperative, because there are so many religions, and Ghana is a secular state. Okay? 3, the motions you have to go through to do that. You have to get the Council of State involved, you have to get Parliament involved, so the motions involved. 4 is simply this election 2024 is so crucial that you don't introduce unknown quantities into the election for people to have issue. That is why we in the NDC as a party will not support any attempt now to move the election date from 7th December to 7th November. No, we won't support it.
Interesting. And that's where we draw the curtains on today's edition of Newsfile. And remember that your Joy News team has got you covered as far as the NPP parliamentary primaries for constituencies that have sitting MPs continues right away. Samson, Lardy, Anyenini, my guests that you have been listening to over the period have been Dr. Yao Ba, Secretary General of the TUC, Samuel Dubik Mahama, Managing Director of the ECG, Ofosu Amwa, Executive Secretary, National Labour Commission, Professor Apieje Etua of the University of Ghana, Martin Pebu, lawyer, and rights activist, was also lawyer for ACP Benjamin Agbojo, Professor Dr. John Osai Kwapong, you just heard him a while ago. Inusuf Hussaini is former Minister, Lands and Natural Resources, and he's also a lawyer. He was also Minister for Roads. Godfred Yeboah Dame, the Attorney General, also joined us. This show has been brought to you by the candid sponsorship of Bank of Africa, strong as a group and close as a partner, MTN, everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 years plus. My Way Insurance. You simply dial *165# on MTN to join My Way today. Syntex Tanks, it's strong, it's tough. And Flamingo Paints, simply superior. I'm Samson, Lardy, Anyenini. Have a good afternoon, but keep your dials here. Continue with the comprehensive special coverage of the NPP's parliamentary primaries.